Hi everyone. The unit we'll be looking at today is criminal law, and we've looked at all the learning outcomes, so learning outcome 1, 2, 3, 4 and 5, and today's session is looking at the assignment area and assignment discussion. But before we do that, I'm going to give you a summary of what we did in each learning outcome, so you have a little bit of an idea before we look at the assignment area. So the first learning outcome was learning outcome 1, and here we looked at the understanding the aims and general principles of criminal law. We looked at the aims of criminalisation of specific acts and the function of criminal punishment. We also analysed the role of public prosecution and criminal standard of proof, and also looked at the capacity to commit a crime. So when we looked at the criminalisation of specific act, we looked at what crime was in English law. We looked at the foundation of the criminal justice system, the nature of criminal law. We looked at, which was quite important, the difference between criminal and civil law, and what it actually meant in regards to taking an action to court. We looked at substantive law and procedural law, and broke down the definition of each one in criminal and civil cases, categories of crime, misdemeanors, felony. We looked at what should or should not be criminalised. We then went on to look at the difference between law and morality in learning outcome 1. We looked at this function of the criminal punishment, things like deterrence, specific deterrence, general deterrence. We looked at retribution. We looked at rehabilitation and the importance of rehabilitating people, such as programs in need for them. Restitution we looked at. Then we looked at the prosecution side, which was the Crown Prosecution Service, how they work, the standard and burden of proof. And finally, we looked at the McNaughton rules in regards to criminal law and some cases such as McDonnell in the United States, Aaron Davies and Aaron Hadfield 1800 in regards to looking at the aims and general principles of criminal law. Then we went on to learning outcome 2, and in that we looked at understanding the elements of the different offences against a person. So we looked at the components of what murder was. So we also looked at the issue in regards to voluntary and involuntary manslaughter, and we looked at the nature of non-fatal offences against the person. We looked at the components of murder, so we looked at the actus and the mens rea, and why they are so important with reference to leading cases. We also looked at the issue of GBH. And we also, which was quite important, is looking at causation, factual and legal causation in criminal liability, and what it was. We referred to cases such as Aaron White, 1910, in regards to factual causation, and legal causations, Aaron Williams, 2011. We looked at other cases such as the Aaron Paget case and Aaron Roberts, and we looked at the thin skull rule under criminal liability, which is R against Haywood. We looked at intention to murder, so direct intention, oblique intention, and we looked at the subjective test. We also, in learning outcome 2, looked at the issue of provocation and referred to cases such as DPP and Bedder and Aaron Duffy. We also looked at the Coroners and Justice Act 2009 and the abolishment of provocation with new defence of loss of control. We looked at diminished responsibility under the Coroners and Justice Act 2009 and looked at cases such as Aaron Tandy, Aaron Campbell, and loss of self-control was another element in learning outcome 2, which we looked at with reference to cases such as Aaron Hatter and DPP and Camplin. We looked at constructive manslaughter, again with reference to leading cases, gross negligence with reference to leading cases such as R and CMO. And we looked at non-fatal offences against the person. So we looked at GBH and the actus reus of GBH and the mens rea of GBH. We also looked at common assault with reference to cases such as Constanza as the leading case, unlawful personal violence. We looked at the mens rea, and we looked at battery and intention, actus reus and mens rea of battery, actual bodily harm, the actus and mens of actual bodily harm, and we looked at the issue of inflicting pain, and also the actus and mens of inflicting. We then went on to learning outcome 3, which we looked at understanding property offences, and we looked at the components of property offences, so distinguish between the lack of honesty under Section 2 of the Theft Act 1968 and dishonesty under common law, compared and contrast robbery and burglary. And when we looked at each one, we looked at these with reference to leading cases. So we looked at the offence that was set out in Section 1 of the Theft Act 1968. We looked at the actus reus and mens rea of theft. We looked at leading cases such as R and Smith, Oxford and Moss. We also looked at the issue of dishonesty under the Theft Act. We looked at the cases such as R and Feely in regards to dishonesty. We looked at dishonesty under common law. And we also looked at the Gosh test. Then we went on to look at robbery and burglary and the actus and mens for that with reference to cases. We looked at, in regards to the cases, we looked at Aaron Dawson and James, Aaron Clouden, so force or threat. We looked at offences under Section 1. We also looked at the actus and mens of burglary with reference to cases such as Aaron Collins and Aaron Brown. Then we went on to learning outcome 4, which we looked at understanding the general principles of incoherent offences. We looked at the types of incoherent offences. We also looked at the meaning of assisting or encouraging a crime. We looked at distinguishing intention to commit a crime from an attempt. We went on to look at the types of incoherent offences, so where they have just begun, undeveloped and incomplete, and these are the main crime has not been committed here. So the planning and the preparation we looked at. We looked at the issue of the features of incoherent offences such as freestanding and harmless wrongs. We then went on to look at the issue of assisting and the issue of attempt under common law and what it actually meant under the Criminal Attempts Act 1981, subsection 1, where it is if with intent to commit an offence to which this section applies, a person does an act which is more than merely proprietary to the commission of the offence, he's guilty of attempting to commit the offence. We looked at the actus reus and mens rea of attempt under the 1981 Act. We went on to look at the various tests for attempt as well, and incoherent offences. We went on to look at another important element which was under common law, which was conspiracy, where 2 or more people have agreed to commit a crime, and there may be, for this is a liability for conspiracy. We looked at the actus reus and the mens rea of conspiracy, and we also looked at the issue in regards to the Section 59 of the Serious Crime Act, where it looked at the issue of assisting and liabilities under the Serious Crime Act 2007. We looked at sections 44 to 46 of the Serious Crime Act, which created 3 new offences of doing an act capable of encouraging or assisting a crime. We then went on to looking at the meaning of assisting and encouraging. So we looked at accomplice liability. Again, in regards to accomplice liability, we looked at the leading case of the case of R and Jogi Rudok and the Queen 2016. We also looked at the issue of principal, secondary and incoherent liability. And we looked at parties to the offence. Again, we referred to the Jogi case in regards to accomplice liability. We looked at the issue of intent to commit a crime from attempt, elements of and defences. We looked at intention, direct intention, and we looked at indirect intention with reference to leading cases such as R and Woolen. We then went finally on to learning outcome 5, where we looked at the understanding the nature and application of defences. We looked at specific and general defences, and we looked at the defence of insanity, duress, mistake, and involuntary intoxication, and the application of self-defence. We looked at self-defence with reference to case law. We also looked at intoxication, duress, necessity. We looked at the defences for insanity, and we looked at cases in regards to this, in regards to what insanity is under Section 2 of the Trial of Lunatics Act 1883. We looked at the 3 key points in regards to insanity. Insanity before the trial, unfitness to plead, and insanity at the time of the offence. And we looked at each one with reference to legal authority, such as cases such as R and Pitchard, 1836. We also looked at cases such as the McNaughton rules, R and Clark and R and Cordia. And we also looked at the defence for duress, defence by threat, and looked at the Hassan case and R and Cole. We also then went on to defence of duress and looked at R and Shalier case, defence by threat, defence of circumstances, and then we went on to look at the defence of mistake and looked at our cases such as R and Tolson and R and Smith. We then went on to looking at self-defence and the importance of self-defence under the Criminal Damage Act 1971 and what self-defence meant. Reasonable force, we looked at Section 76(3) of the Criminal and Justice in Immigration Act 2008. We looked at Bedford case and Gladstone case. We also looked at reasonable force objective element, and we looked at excessive force in the issue of the leading case of R and Clegg. And that was it for learning outcome 1, 2, and 3, where we summarised what we needed to do in that in regards to the assignment area. This is just an idea of the module, what you need to do to identify a pass, merit and distinction for each learning outcome, and the indicative content which needs to be looked at when doing the assignment. I'm now going to go on to the assignment and identify what you need to do for this area. I'll just share that with you now. So the assignment is just below there. So we'll go through the assignment area now. So the unit you are doing is criminal law. It's a level 4 unit and it's 30 credits. Okay. The assignment, now we'll start with, it's a scenario with some tasks under it. Okay. So the assignment, you are working for a law firm and have been asked to prepare notes on 2 potential criminal cases in advance of a meeting to discuss a way forward. You are also asked to produce some introductory information for 2 new paralegal employees who will be attending the meeting as part of their training. You should explain the legal terminology used. In task 1, Task 1, introductory notes. The introductory information you have been asked to provide is about criminal law, punishment, prosecution, and proof. Your notes should include the following: to evaluate the aims and criminalisation of specific acts and the function of criminal punishment, AC 1.1, to analyse the role of public prosecution and criminal standard of proof, AC 1.2. When you are doing this assignment, please make sure you put the headings in and also use Harvard referencing when you are referencing any work, okay? The headings will identify what learning outcomes and what parts of each task you have completed, okay? Make sure you have your name, your ID number on the assignment and the unit code and the level, okay? That is task 1. Task 2, Handley and Franks. Tom Handley was involved in a fight with Gerard Mayton after visiting several pubs on Friday evening. Gerard was badly beaten and later died from his injuries. The investigation suggests that Handley had been looking for Mayton to pay him back for stealing his girlfriend. Alfred Franks, Tom's friend, is said to have been encouraging the confrontation. Both Handley and Franks have been arrested and are facing possible murder charges. Franks is also facing a common assault charge for threatening one of Mayton's friends who tried to come to his aid. Handley is saying he was too drunk to realise what he was doing and that Mayton threatened him first and he acted in self-defence. Handley and Franks attempted to leave the scene in Handley's car, with Handley driving, even though he was over the legal limit, but stopped when the car hit and knocked down Handley's ex-girlfriend as they were driving away. Franks claimed that she had run out onto the road and to stop Handley leaving and then knocking her over was an accident. You are required to write notes pertaining to the defence of Handley and Franks. You need to consider the basis for the potential murder charge and possible defences in relation to the case. Your notes should include the following. So please make sure they are headings so you are able to identify you have done task 2, task 1 with each element of it. So the first bit is analyse the components of murder. And here you will be looking at AC 2.1. Then you need to illustrate circumstances giving rise to voluntary and involuntary manslaughter, and that's AC 2.2. Then you need to assess the nature of non-fatal offences against the person, AC 2.3. Then you need to look at assessing the types of incoherent offences, which is AC 4.1. And then you need to look at examining the meaning of assisting or encouraging crime, AC 4.2. And you need to examine specific and general defences, which is AC 5.1. And you need to illustrate the application of self-defence rule, which is AC 5.3. Now, to gain a merit in task 2, you need to also look at additional things that you need to do. Okay, so for a merit, you must also assess the force as a mere evidence of intention, and that would be ACM 2.1, and you would need to highlight that you have done that. Then you would need to distinguish between accomplices and secondary parties and derivative and incoherent liability. That's ACM 4.1, okay? To gain a distinction, which again is additional for you to do, you must also look at critique the appropriateness of negligence as forms of mens rea, ACD 2.1. You need to evaluate any deficiencies in existing rules and proposals for reform, which is ACD 2.2. You need to assess the impact of the Convention on Human Rights on Defences, ACD 5.1. Now, these are additional to the past requirements, so it is up to you if you want to do the additional extension activities, which is merit and distinction, to gain the marks. Then we'll go on to task 3. Bromley and Son. In task 3, Peter Bromley and his 12-year-old son, Mark, were apprehended, apparently breaking into and entering a property. At the time, Peter was standing outside the property and Mark was inside the property, having climbed in through a window that had been forced open. Mark was disturbed by the owner and caught trying to escape by the back of the door after an unsuccessful attempt to threaten the owner into giving his valuables. As far as the owner is aware, nothing was taken. Peter was found in possession of a bag of tools, which he says he borrowed from an unlocked van parked outside the neighbour's house. Peter also says that he was confused, having taken some strong painkillers prescribed for his back earlier in the evening and thought the house was his mother's house. He claims that he had knocked and not had an answer, so Mark climbed in through the window, which was already open, to check that she was all right. Mark has a different story. He says that his father forced him to enter the property, having forced the window with a crowbar from the bag of tools, with the instruction to steal anything that looked valuable. Mark has learning difficulties and has a mental age lower than his actual age. Peter claims that because of his learning difficulties, Mark is quite mad and doesn't know what he is doing and what he's talking about. You are required to write notes pertaining to the defence of Peter Bromley and his son, Mark. You need to consider the basis for the charges that he may be brought pertaining theft or of the tools, burglary and robbery, and possible defences in relation to your case notes. You should look at the following elements. So firstly, you need to explain capacity to commit a crime under AC 1.3. You need to explain the components of property offences under AC 3.1. You need to also look at distinguishing between lack of dishonesty under Section 2, subsection 1 of the Theft Act 1968 and dishonesty under common law under AC 3.2. You need to compare and contrast robbery and burglary, which is AC 3.3. You need to distinguish intention to commit a crime from an attempt, AC 4.3. You need to examine specific and general defences under AC 5.1, and you need to illustrate the defence of insanity, duress, mistake and involuntary intoxication under AC 5.2. Now, for the extension activities and for the additional marks for a merit, you must also evaluate the meaning of conditional attempt, which is ACM 3.1. The assignment submitted by learners must achieve the learning outcome and meet the standards specified by the assessment criteria for the unit. And to achieve the merit or distinction grades, the learners must demonstrate they have achieved all the criteria set out for these grades. Where work for the past standard is marginal, assessors will take account of extension work completed by the learners. So you need to make sure that you are completed all the learning outcomes. For the tasks, task 1 here, the assessment criteria is LO1, AC 1.1, 1.2. As a general background, the learners should provide information about the role and the nature of criminal law. So to gain these marks, how acts are criminalised, the different functions of criminal punishment, and the role of the CPS and the burden. Learning outcome 2, AC 2.1, 2.2, and 2.3, M21, D2.1 and D2.2, and learning outcome AC 4.1, 4.2, M41, and LO5, 5.1, 5.3, and D5.1. Here you need to look at the meaning of death, legal and factual causation, the intention to murder in relation to the given scenario. You'll also need to look at the mens rea and the foresight, They will also consider the case of manslaughter as opposed to murder. You should refer to the Homicide Act 1957 and consider the meaning of diminished responsibility. You also need to consider whether Franks can also be charged with murder because of his involvement. And you would look at the leading case here of the Jogi case in regards to his accomplishment liability in assisting and encouraging the incident. In relation to the threat by Franks to a friend of Mayton's, they need to consider the possibility of an assault charge. Learners should look at the issue of negligence as forms of mens rea in relation to the road traffic accident involving the ex-girlfriend. They will also need to look at intoxication as a defence and Handley's claim of self-defence, and also include look at the impact of the human rights on defences of self-defence and look at the deficiency in existing rules and current reform proposals. So that's for task 2. The next one is for task 3. You need to look at learning outcome 1, AC 1.3, a learning outcome 3, AC 3.1, a learning outcome 3.2, 3.3, M3.1, learning outcome 4, AC 4.3, learning outcome 5, AC 5.1, 5.2. Learners need to look at the crime of theft. So you need to look at the Theft Act 1968 and the tools which Bromley Senior claims he had borrowed. You need to look at determining whether a crime has been committed or simply an attempt, and the difference between burglary and robbery. You need to also look at, consider whether Mark Bromley has the capacity to commit a crime, and also look at the issue of defences, insanity, duress, also mistake or involuntary intoxication, and also look at cases as well in regards to that, such as Aaron Allen, Aaron Kingston, and you need to look at exploring the intent to commit the crime, including conditional intent. You need to also look at the issue of whether he had the capacity to commit the crime because of his disability, and also refer to cases in regards to that. And to do that, you need to, obviously, if you want to gain a merit, you've got to then look at the intent to commit the crime and the extension activity, which was the meaning of conditional intent. You also need to make sure that the learners, you demonstrate that you have achieved the learning outcomes at the standards provided of the learning criteria. Make sure that you are using actual examples, legislation and case law to illustrate the points which are made. And in the PowerPoint slides, there are a lot of cases that you can refer to when completing the tasks, which you need to be looking at, as it's quite detailed and in depth. There are also additional resources on Moodle that you can use. Learning outcomes 2, 3, 4, and 5 can largely be assessed in a practical context, and the learner should be provided with suitable scenarios, as we have done in the assessment guidelines. And you need to be obviously looking at the aims of each task that you need to complete, which is above, and also with reference to if you want to do the additional extension activities to gain a merit or distinction, you need to do them. Make sure, please, again, I will reiterate this, make sure that you have headings, you use Harvard referencing, and you identify the tasks as well. Put your name on there, put your ID number on there, and the module you are doing, you identify the task numbers with the elements of which learning outcomes you are doing. Thank you for your patience, and thank you for attending this session. Thank you. Bye.